Hello, my name is F.J. Collins. I'm an attorney in Baltimore, Maryland. I'm going to speak to you today about employment law for at-will employees. Essentially, these are employees who are non-governmental employees and who are non-unionized employees. In most states, including Maryland, if you do not have an employment contract or a union contract, or you are not a governmental employee, you are considered an employee at will. That means you can be fired at any time for any reason, as long as that reason is not an illegal reason. Generally speaking, an illegal reason would be because of your race, creed, color, religion, national origin, gender, handicap, sexual orientation, and a few other categories such as for serving jury duty or working in the military or the National Guard. Essentially, if you are an at-will employee, you can be fired at any time for any reason other than one of those illegal reasons. Indeed, you can be fired for false reasons. For example, you could be fired because you are accused of having stolen money from the company or your employer, when in fact you had not. If that occurs, the employer is entitled to terminate your employment, even if that reason is false. Some typical examples would be if you are fired for wearing the wrong colored socks. Obviously, wearing the wrong colored socks is not a good reason for firing you. But if that is the true reason that your employer terminates you, then that is a legal reason. Now, obviously under those circumstances, being fired for wearing the wrong colored socks is questionable. You would say maybe there is another reason, and maybe the employer is giving that reason as simply a pretext for an illegal reason. And if that illegal reason is really your race, creed, color, religion, national origin, or some other illegal reason, then the excuse of having fired you for wearing the wrong colored socks would not apply. This is obviously not a comprehensive evaluation or explanation of all employment law. You should clearly, if you are terminated and you think that the reasons are wrong, and you want to find out whether or not you were properly terminated or whether you have a lawsuit that can be filed against your employer, you should seek the advice of a competent employment lawyer who works in this field all the time. Because this is not a field where there is insurance coverage, and also because these are difficult cases, and the vast majority of cases or vast majority of terminations are done for legal reasons, it is not always that easy to find an attorney that can handle this kind of case. So you may need to do some extra searching. And also, most employment lawyers will not handle cases, at least initially, on a contingency fee, meaning you would pay a percentage of what you recover. For example, in my situation, I always charge an initial consultation fee of $300 just to consult about your possible case. Sometimes thereafter I will charge a contingency fee, but that initial consultation fee is intended to compensate me for my time in consulting with you and also to weed out frivolous cases. So if you think that you have a valid case, you should definitely seek the advice of a competent attorney before basing a decision solely upon the advice given in this video.